You're not going to believe this, but a case about a few junk faxes went all the way to the Supreme Court. And in the process, it completely redefined the rules between our courts and powerful government agencies. So let's dive in and see how this tiny little case created such massive waves.
It all comes down to this number, $6,000. That is all that was left of a massive multi-million-dollar class action lawsuit. So why did it shrink so drastically? Well, it's because a lower court felt its hands were tied by a brand new rule from a government agency. That move basically gutted the entire case, but it teed up a much, much bigger fight.
And yeah, this was no overnight battle. I mean, just look at this timeline. The faxes went out way back in 2009. The lawsuit gets filed 5 years later in 2014, and it took all the way until 2023 for the Supreme Court to finally weigh in. That's a 14-year journey from a fax machine to the highest court in the land, which just shows you how high the stakes really got. So where did this whole thing even start? Well, it all kicked off with a pretty simple conflict, really. A small business versus a giant corporation, all because of a law passed back in 1991 that was meant to stop those annoying telemarketing calls.
Okay, so that law is the Telephone Consumer Protection Act, or TCPA. It's designed to protect all of us from, super intrusive marketing. But here's the kicker, the part you really need to pay attention to, the penalty. It allows for a minimum of $500 in damages for every single violation. When you're talking about sending out thousands of faxes, those numbers can balloon like crazy. And that's where McLaughlin Chiropractic comes into the picture. They sued this huge healthcare company, McKesson, not just for themselves, but on behalf of everyone who got these faxes. And here's the detail you got to remember, because it becomes the whole ballgame. Some people got the faxes on old-school physical machines, but a lot of others got them through modern online fax services. That little distinction is everything. At first, the case seemed pretty straightforward, right? But then, right in the middle of everything, a federal agency just throws a massive wrench in the works. It completely changed the game.
Yeah, we're talking about the Federal Communications Commission, the FCC. While this lawsuit was slowly making its way through the system, the FCC just drops a new ruling. It's called the AmeriFactors Order, and for this case, it was an absolute bombshell. So what was the big deal? Well, it's all right here. The original law, the TCPA, banned junk faxes sent to a telephone facsimile machine. Simple enough. But the FCC's new order comes in and says, well, actually, we're interpreting that phrase to exclude online fax services. And just like that, a huge chunk of the lawsuit was suddenly on really shaky ground. So the district court looks at this new FCC rule and basically says, well, our hands are tied. We have to follow it. And that decision completely gutted the class action because remember, most people used online services. All that was left were the 12 faxes that McLaughlin got on their old physical machine. And boom, a multi-million-dollar case, gone, shrunk down to just $6,000. Now this is why it ends up at the Supreme Court. The question wasn't really about junk faxes anymore. It was way bigger. It was about who gets the final say on what a law actually means. Is it the agency that writes the rule or the court that's hearing the case? And the reason the court felt so stuck was because of this law, the Hobbs Act from 1950. It says that specific courts, the courts of appeals, have exclusive jurisdiction, meaning they're the only ones who can review these agency orders. And here's the other thing. You've usually only got about 60 days to challenge a new rule. That's it. Okay, so here is the million-dollar question. Does that phrase, exclusive jurisdiction, mean that if nobody challenges a rule in that first 60-day window, it's just set in stone? Does every other court in the country have to just blindly follow it forever, even in a totally separate case, years and years down the road? So what did the Supreme Court have to say about all this? They took the case specifically to untangle this really complicated knot between the courts and federal agencies. And man, their answer, delivered by Justice Kavanaugh, could not have been more clear or more direct. He wrote, "Are district courts bound by the Federal Communications Commission's interpretation of the Act? The answer is no." Wow, just a flat-out, unambiguous no. Okay, so what was their reasoning? Well, it all comes down to this really important default rule in our legal system. There's a basic assumption that courts can always review what an agency does. They're meant to be a check on that power. And that check always exists unless Congress steps in and says, in very clear, very explicit language, nope, not this time. The court basically laid it out in three different scenarios. First, you have challenge now or never laws, like the Clean Air Act. They literally say you can't question a rule later on. Then you have laws that say you can challenge a rule both now and later. But the Hobbs Act? It's silent on the issue. It doesn't say you can't challenge it later, and in law, that silence means a lot. It means that default rule we just talked about kicks in.
They also pointed to this old case from World War II called Yakas. And look at the difference here. The law in that case had this extra sentence with really powerful language, saying no other court could even consider if a rule was valid. But when Congress wrote the Hobbs Act years later, they left that part out. The Supreme Court looked at that and said, hey, that wasn't an accident. Congress intentionally left the door open for courts to take a look later on.
So let's zoom out for a second, because this isn't just about faxes anymore. Not by a long shot. This is about the fundamental relationship, the very balance of power, between the courts who interpret our laws and the agencies who carry them out.
So what does this all mean, really? Well, first, it confirms that courts get to be an independent check on federal agencies. It also means people and businesses get a second chance to fight a rule when it's actually being used against them. And think about it. This is a huge deal for, say, a new business that didn't even exist when a rule was first made. It stops agency rules from becoming unchallengeable law just because a short 60-day window closed years ago. But not everyone was on board with this. Justice Kagan wrote a really powerful dissent, arguing that this decision creates all sorts of instability. She painted this picture of a company, even using the extreme example of a plutonium shipper, that could just decide to ignore an agency rule it doesn't like, wait to get sued, and only then challenge the rule in court. It's a pretty compelling argument about the need for rules to be reliable and for people to actually follow them.
At the end of the day, this whole case shines a huge spotlight on a central tension in modern government. And it leaves us with this big question to chew on. These federal agencies write thousands of rules that impact our daily lives. So when they interpret the laws that Congress passes, how much power should they really have? And when does that power become too much? This ruling drew a new line in the sand, but you can bet this debate is far, far from over.